Thank you. Justice Thomas, anything further?
Mr. Stewart, just a couple of questions that just satisfied my curiosity. One on the merits. Could you, if the government determined that certain media outlets had an outsized influence on election, could it similarly limit the amount that they spend on editorials to equalize the influence?
No, it could not do that, and it could not do that with candidates. That is, this is not a limit on the amount of money that a candidate can spend or even the amount of money that the candidate can loan. It's purely a limit on the funds that can be used to repay the candidate loan after it's been made.
I don't quite see the difference, but okay, my final question is, going back to your standing, you said a number of times that these self-inflicted injuries can't be a basis for standing. At least that's what I understand. But how would you, using that at that level of generality, what would you say about Plessy sitting in the wrong car?
We would not say that that is self-inflicted in the relevant sense.
Why not? I mean, it's just all he has to do is go to another car.
That is, Plessy is attempting to assert a legitimate constitutional right and is attempting to do something in the real world that presumably he would do if the law were not on the books. That is, if there had been no law mandating segregation on the means of transportation, presumably Plessy would have sat in an integrated section and would have had an interest in doing so. This is self-inflicted not just in the sense, it's a different case when plaintiffs stand on their rights and insist on doing what they would do if the law were not in effect and experience injury as a result of it. This is a case in which the plaintiffs did something they would not otherwise have done solely for the purpose of being injured and then filing a suit.